All right, this is case number 253294 SD, appearances counsel.
Even if you're
No.
Even if we're Mr. Hahn. It's not for this case, I apologize.
We are here for a final pretrial. Is there any resolution in this matter?
I was thinking that it would be guilty to the operating while visibly impaired, the people who dismissed counts 1 and 2. We do not have that, but we do have a PBT.
Ms. O'Mara, is that your understanding of the plea agreement?
That's my understanding, yes.
Is there a stipulation to use the PBT and as opposed to the blood draw?
Yes, sir.
Ms. O'Mara, have you had the opportunity to discuss that issue with your supervising attorney?
I would consent to that, Your Honor.
You're okay with that, Mr. Hartel?
Yes, Your Honor.
All right. Okay, Mr. Hahn, have you heard what the attorneys have said the resolution in this case is?
Yes, Your Honor.
And is that how you wish to resolve it?
Yes, Your Honor.
All right. Will you please raise your right hand? Do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
May put your hand down. It's my understanding you'll be pleading guilty to count what is essentially a count number 3 of operating while visibly impaired. That is a 93-day misdemeanor and or a fine of $300. The 93-day misdemeanor means that I could put you in jail for up to 93 days. Do you understand that?
I do, Your Honor.
In exchange for that agreement, the people will be dismissing the count number 1 of operating with a high BAC or bodily alcohol content and count number 2 of operating while intoxicated. Now, do you understand that if this case were to go to trial, the people would only be able to try you on one or the other count? They couldn't try you on both. Do you understand that?
Yes, Your Honor.
And does that have any impact on your decision to enter a plea today?
No, Your Honor.
All right. Is that your full understanding of the plea agreement?
Yes, Your Honor.
Back on July 15th of this year, were you on probation or parole?
No, Your Honor.
Were you on bond?
No.
Do you remember reading and signing this advice of rights form? Talked about your rights to an attorney and your rights to a trial.
I do.
Did you understand those rights?
I do.
Do you have any questions for me about those rights?
No.
Most importantly, do you understand that you have the right to have a trial, and by entering a guilty plea today, you'll be giving up that trial and you won't have a trial of any kind?
I do, Your Honor.
Then to the, other than the plea agreement, has anybody promised you anything?
No, Your Honor.
Has anybody threatened you in any way?
No.
And is it your own free choice to plead today?
Yes, Your Honor.
Are counsel aware of any other promises, threats, or inducements not made part of the record?
I'm not.
No, Your Honor.
Then, Mr. Hahn, to the allegation that on or about July 15th, 2025, in the city of Cadillac of Wexford County, how do you plead to operating while visibly impaired, guilty or not guilty?
Guilty.
In order to accept that plea, I must have you tell me what it is that makes you guilty. So back on July 15th, were you operating a motor vehicle in the city of Cadillac?
I was.
And prior to that, had you consumed some alcohol?
I did.
How much had you had to drink?
5 to 6 beers.
What type of beer?
Bell's variety.
Okay. And do you believe that consuming that amount of beer would have visibly impaired your ability to operate a motor vehicle?
I do.
All right. Do counsel believe the defendants provided a factual basis to accept the plea and the court rules have been complied with?
I do.
Yes, Your Honor.
And just for the record, because we have a stipulation, what was the PBT amount, Ms. Curie?
187.
All right, the court agrees. I find the plea is knowing, voluntary, and accurate. Mr. Hahn, I find you guilty of operating while visibly impaired pursuant to the plea agreement, the operating with a high BAC, and the operating while intoxicated will be dismissed at the time of sentencing. Do we need to set this over for a substance use assessment?
We should already have our ER that's completed. I don't know that you guys have.
Has counsel received a copy? Sir, when did you have it done?
I had it done pretty quickly after my first pretrial, and it should have been sent over to the public defender.
What, did you have that done by Catholic Human Services here or somewhere else?
Catholic Human Services. They called and finished it over the phone. They said they were going to send it to my public defender.
We have not received a copy. Of the defender's office received a copy?
I don't believe I have not, no.
All right, what we'll do is we'll set this out then for sentencing because we don't have that assessment. We'll set it out for a couple of weeks, but if something happens that the defense office is able to get that sooner, we can always get it back on for sentencing sooner. Just a reminder that your bond conditions continue. Question?
Your Honor, I've already been paying for the breathalyzer thing to take home for the past 2 months, and it's been, pretty expensive. And I'm working 2 jobs where it's kind of difficult to have access to it every day. I was hoping maybe you could, if the bond conditions still apply, I was hoping maybe you could waive the testing since I've been doing it for 2 months and successfully completed them every day.
So I only ordered random testing. Did you choose to do the daily blow machine?
I live in a really rural area.
Sure.
And I live an hour from here, so to do the randoms is more inconvenient than having it at home. So, but I've already, it's already been over $600 to have it at home. To have it any longer is kind of tough on my finances since I've already lost my career due to, this incident. I was a commercial driver, so I've changed careers. I got two jobs now, and I'm working like 70, 80 hours a week to make ends meet now. So hoping maybe if anything, we could waive the breathalyzer.
That's correct.
I think either people would object to that, Your Honor. He's, given the high PBT, there also was being on the lookout for his poor driving. That's how he was located. Was due to his multiple vetoes put out for him. And given the fact that he entered a plea, I think that if he already has the SUA done, we can get it back with it probably next week. So I would say, I would ask the court to continue the testing. I mean, he does have the option for random, it sounds like, so.
What I'm willing to do, I'm not sure if I see 3 attorneys here from the defense office. Is anybody able to try to get a hold of Catholic Human Services to see if we can get an assessment sent over to us? And we can do sentencing today?
I'll look at.
All right. So, Mr. Hahn, what we'll do is I'm going to adjourn right now. I'll have you hang around a little bit to see if we can get your assessment.
Okay.
If we can get it, we'll sentence today.
Okay, thank you.
Okay. If not, I'll make a decision about your request.
Thank you, Your Honor.
Mhm.
Appreciate it.
All right, court recalls the people of the state of Michigan versus Michael Anthony Hahn, case number 253294 SD. Ms. Carey, this was your case, right?
It is.
Yes, Ms. Carey on behalf of the people, Ms. O'Mara on behalf of the defendant. I have had the opportunity to review the substance abuse assessment. Ms. Carey, have you?
I have.
Ms. O'Mara, have you?
Yes, sir.
Did you have the opportunity to go through that with your client? Do either party have any additions or corrections to the assessment? All right, then allocution, Ms. O'Mara.
Your Honor, I believe Mr. Hahn will better be able to allocate on the level of perceived mistake, or I was going to say stupidity, but I don't want to insult my client involved in this incident. But it was a dumb mistake. He doesn't have a criminal history. I don't believe that he really has an extended problem with alcohol. Or just situations where you drink too much to make a poor decision. When it comes to punishment, I think that he's been punished a lot already. Less the financial, but he's had to stop working where he had been working. He lost his commercial driver's license. He's got 2 new jobs that don't pay as well. He's working more hours. Now he's working, he said 80 hours a week most weeks. And I believe that he understands already through the consequences of what's happened, the gravity of his mistakes and the severity of what he's done. So I'd ask for a short-term probation. Thank you, Your Honor.
Thank you. Ms. Carey?
Well, there are consequences for actions, and he's learning about that, but I think simply a period of probation is appropriate, given the high VAC that he had. According to the PPT, and we're not sure, but it's usually close. They're usually not far off. The PPT was a 0.187. That's a practice drinker. If you can get that and get behind the wheel, that's very concerning. And the fact that there was a VOL, his driving was not good. He then hit a curb and got a flat tire. All of that is of concern. And I probably wouldn't change. I didn't see in the assessment level for this, for whether it was, maybe I missed it, but no criteria, mild, severe, moderate. I didn't see that. They also didn't have the results of any breath test or blood test when they did this assessment. So given the circumstances of this case, I do believe a period of probation is appropriate.
Thank you. Mr. Hahn, you have the right to address the court prior to sentencing. Is there anything you'd like me to know?
I just wanted to say I'm very apologetic to all the people in the state of Michigan. I know what I did was completely reckless and I regret it very much. I don't plan on drinking ever again, to be honest with you, because this has completely ruined my life. And I definitely not someone who's had an alcohol issue, but I definitely made a mistake that night getting behind the wheel, and I know that. And I'm just doing everything I can to correct the situation. Like I said, it's been detrimental knowing that my career that I've worked so hard the past 10 years to build myself up as a commercial driver is just over. And you know, yeah, I guess I just want to say I'm sorry for it.
So when had you stopped drinking before driving?
About an hour.
Okay. And what time of day or night did this happen?
This was, I believe, around 9:30, 10 o'clock.
In the evening?
Stop was, yeah,
All right. And the assessment said you were coming back from camping and you blew a tire?
yes.
Were you hauling a camper or a vehicle?
No, I was at a campground with some friends.
Okay, all right. And then you pulled over and law enforcement was,
Pulled over and law enforcement got behind me pretty quickly, yes.
so what do you think was different this time than other times? I mean, you know, PBT of a 0.187. And you report not being that big of a drinker, but you got to that level, so I guess help me understand that a little bit. What had you been drinking?
That was too hard to do. It's pretty strong.
Okay,
beer.
that's right.
It's a strong beer. And I think I just kind of lost track, honestly, I think I just kind of lost track that I had, you know, that many beers. And
Were you headed back to Stanwood?
yes,
And so this happened in the city. Was this on the express? No, it says Mitchell Street. So you were in town. Where did you blow the tire at? If you know.
somewhere on Mitchell Street. I'm not super familiar with the area.
Okay.
I was just following my GPS.
Okay. Where were you coming from?
Interlochen State Park.
So you traveled quite a distance then,
Yes, Your Honor.
in the grand scheme of things.
Yes, Your Honor.
Have they taken any action on your license yet?
No, Your Honor. I just, judging from my first pretrial, I just trying to get ahead of it, and figure that the Secretary of State, you know, once I get convicted of any kind of alcohol charge, I'm gonna lose my CDL. So I put in my 2 weeks a while back and started looking for other jobs, and my area, and unfortunately, my area is very rural. I was driving an hour to get down to Grand Rapids from Stanwood area.
So that's where you were based out of, was Grand Rapids?
Correct, Your Honor. And so, yeah, I found some work more closer to home because I was worried I was gonna lose my license. And
So are you working out of Big Rapids then, or?
I'm actually working out of Remus at Bandit
Okay.
Industries.
Okay.
Wood chippers. So I'm grateful I was able to find new employment, but it's a lot less pay. I'm kind of starting back from scratch. I started off in the warehouse industry before I became a commercial driver, so I'm kind of like starting back from the bottom and I have to work myself back up. Because when you get an alcohol charge like this, you can't get a driving job for at least 10 years or so before anyone will really hire you again. So I'm just kind of getting ahead of it with everything like that, but unfortunately I have to work 2 jobs to make ends meet right now because my bills are pretty high. And my other jobs pay a lot more than these ones do now. So,
And you were, worked for Vital Records Transport, if I remember correctly?
yes.
So the assessment says that there's a need for brief intervention. What do you think about that?
Not sure what to make of that. I thought the assessment went pretty well, and I don't really think I need an intervention. I think this experience has been detrimental to me as far as like I do not want to drink. I don't think I had an alcohol problem per se, but I mean I had drinking before in my life. You know, it was like as it says in there, I was a weekend drinker. You know, always responsible. I'm a big advocate for not drinking and driving. So unfortunately, this night is very out of character for me, and I really regret it. But at this point, alcohol has affected my life in such a negative way. I don't want anything to do with it. I mean, this is something I can never enjoy it again. I don't think it's ruining my life completely. So I think that I don't think I necessarily need an intervention. I think this has been a huge intervention already for my personal psyche.
Anything else you'd like me to know?
Oh, Your Honor.
The law says that in cases like this, we start with a presumption of no probation and no jail. However, that is a rebuttable presumption. What I have is a person who's 34 years old. My reading of the assessment indicates that he does not meet the criteria for a substance use disorder at the time. However, it does state that there's a need for a brief intervention. It is concerning to the court that he was a .187 and had driven from the Interlochen State Park. He was stopped essentially because of getting a flat tire. Was there? There wasn't a B on the lookout. There was a B on the lookout for this vehicle. All right. I also have somebody who does not have any convictions in his past. There may have been something out of state. I couldn't really tell, maybe a delay of sentence in a dismissal, but I'm not sure of that, the way the out of state record reads. Mr. Hahn, I think it's going to be beneficial for a period of probation. I've got 24 months at my disposal. I'm not going to put you on the maximum amount because I don't think it warrants that. But I do think, given the level of intoxication, to be on the lookout, how far you drove under that level, I do think gets us over the presumption of no probation in this case. So I think a period of probation is appropriate. I'm going to put you on a period of probation for 12 months. Now, this offense does allow you to be released early at the halfway mark. So when we get to the 6 months, if you've done everything we need you to do, and you haven't had any violations, or it's been sufficient amount of time since your last violation, you could be released early. Now, if something happens that your probation officer doesn't think that you should be, but you think you should, you can petition the court on your own and we'll have a hearing and I'll make that determination as to whether or not you should be terminated early. Do you understand that?
I do, Your Honor.
During the period of time that you're on probation, you are not to violate any law, report as ordered, not leave the state without the consent of your probation officer, keep your contact and employment information current, While on probation, I want you to attend the alcohol highway safety education class and the victim impact panel. I'm also going to order that you not consume any alcohol. And I know it's been a while since you've used marijuana, at least according to the assessment. I'm going to order no illegal drugs and no recreational marijuana because I don't want you trading one substance for another. I realize it says that you don't have an issue, but I just don't want that temptation there, if that makes sense. You'll be subject to testing pursuant to the terms of your probation officer. I also want you to follow any substance use assessments and recommendations. Normally, I would order no bars and restaurants or no bars are the primary source of alcohol. Sale of business is sale of alcohol. I don't think I need to do that for you, so I'm not going to do that. I'm also going to order that you attend any additional programming that your probation officer feels is appropriate, including any counseling for drugs or alcohol. All right, those are kind of lumped together. There is a $75 crime victims rights fund fee, $50 state minimum fee, $150 court costs, $150 fine, $150 attorney fee. I'm only going to charge you for 6 months of the probation, which is $180. If something happens that you stay longer than the $180, you'll be required to pay that monthly fee. Ms. Carey, is there any reimbursements requested?
There is to the city of Cadillac Police and the prosecution.
$100 to the prosecutor
Yes, please.
and CPD, how much?
There was a blood draw. We don't have the results yet. $200.
Mr. Hahn, in certain circumstances, the prosecutor and law enforcement are able to recoup a portion of the expense in prosecuting these types of cases, and operating while intoxicated happen to be one of those. So there is a $100 fee back to the prosecutor and a $200 fee back to the city police department. There is 1 day jail with 1 day credit, so you've sat your time. Because I have sentenced you to a term of incarceration, even though it's time served, you do have the right to appeal that decision. If you decided that you wanted to appeal it and could not afford an attorney to assist you in that regard, you have 14 days from today's date in which to hire or request the court to appoint an attorney. Do you understand that?
I do.
Also, any balance that remains unpaid for more than 56 days will have a 20% penalty assessed to that by operation of state law. I'll need you to go out to the front window where you checked in, get a copy of your judgment, make a payment if you're able to, and then go downstairs to the district court probation office and get signed.
All right, let's talk about that. Michael Anthony Hand's case gave us a full tour of how a plea, a request for leniency, and a sentencing play out when a judge wants to be both fair and realistic. Judge Middleton presided, and what stood out was his balance of measured skepticism with a willingness to recognize genuine remorse, guilty to operating while visibly impaired, a reduced charge that came with dismissal of the higher counts of operating with a high back and OWI. He admitted to drinking 5 or 6 strong beers before driving, and his PBT landed at a hefty .187. On the record, that number alone was concerning, and the judge highlighted it as more than enough to clear the threshold for visible impairment. Hand's demeanor was cooperative and respectful. He owned up to the drinking, admitted his driving was impaired, and didn't try to spin excuses. He even spoke about how the arrest had effectively ended his career as a commercial driver, forcing him to take on 2 lower-paying jobs just to stay afloat. During his attorney struck a careful balance, acknowledging it was, in her words, a dumb mistake, while emphasizing that Hahn didn't have a criminal history, wasn't a habitual drinker, and had already paid dearly through lost employment. Hahn himself doubled down on remorse, telling the court he regretted the decision deeply, had no desire to drink again, and understood the severity of what had happened. His words came across as earnest, and he even described this case as an intervention in itself, making it clear he didn't see alcohol in his future. The prosecution was to leniency, pointing out that this wasn't a minor slip. There had been a be on the lookout alert for his vehicle. His driving had drawn concern, and he ended up with a flat tire after hitting a curb. Pairing that with a BA pushing .19, the state argued probation was necessary, not just fines. Judge Middleton agreed, stressing that while Hand's clean record and obvious regret mattered, The sheer risk created by his level of intoxication and distance driven couldn't be ignored. In sentencing, the judge imposed F probation with a chance for early release at 6 months if Han complied fully. Conditions included alcohol safety education, a victim impact panel, random testing, and a ban on both alcohol and recreational marijuana. Fines and costs were kept moderate with some fees waived, but restitution was ordered to cover prosecution and police expenses. Han received 1 day in jail with 1 day credit, meaning no additional time behind bars. The judge was clear. This wasn't the maximum, but it was enough to underscore accountability while still leaving room for Han to rebuild his life. The overall courtroom atmosphere was serial full. The defense highlighted humanity, the prosecutor stressed risk, and the judge struck a middle ground that leaned towards supervision and accountability over punishment for punishment's sake. It was a good example of a courtroom functioning as it should: firm, fair, and always with an eye on the bigger picture. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.